Okay, good evening once again, and we can get started. And this is Doreen, your host tonight, Rubber Care Center, that is bringing this conversation to us. And I'm glad to see you in the call, and we are set to learn. And I'm also glad that our good advocate of the High Court of Kenya is together with us, ready to give us this information. And so, welcome. And let's learn together. I'm also ready. I hope you have your notebook, you have your pen with you, because we're gonna write these things and start doing them. So I think we needed to start early enough so that we can allow her to give us all the wisdom that we need. Because I'll say this, yes, we invest a lot, we take time doing many things, every other day is a day to go out and bring things on the table, or even bring the table itself. And so we need how to get to know how to plan accordingly, because as I say, there is no permanence on this side. So it's good to embrace some of these things, because I've seen issues that are left behind, people with lots of wrangles. And also, when you look at the unclaimed assets, because I'm also interested to hear, I know our good advocate is going to bring that to our attention. There is so much there, and I'm sure some of us got an experience of the same. So we don't want to lose out on some of these things. This is part of us. This is part of life. So I want to say most welcome, and let's be set to learn and be able to execute some of these things. Yeah, I'm so much ready also to get to know how to go about this. So without much ado, because I really wanted us to get to hear so much today on this, and also ask as many questions as we can. I wanted us to have good time, and be able to do this. Allow me to say a word of prayer as we start this meeting. Father, we are so grateful tonight for the gift of life, and indeed allowing us to meet, and also for good health, that we are here today and we are well. We don't take this for granted. We choose to bless your name, and indeed thank you for according all these things to us, and also giving us the ability to make wealth. I thank you, and I pray even tonight as we hear on matters, on the wisdom around how to live intentionally, and also to plan well. I pray that you're going to help us, oh God. Be together with us as we begin and as we go through this conversation tonight. And we pray that you're going to help each one of us. In the name of Jesus, we pray and believe. Amen and amen. And I'll say this even as I hand it over to Esther. I want to say this. When we talk some of these things, it's not that we are saying we are dying tomorrow. Not quite. And I'm sure matters around death also needs to be addressed, so that we can be able to know exactly how to go under the sun, how to do business under the sun. So when we hear some of these conversations, they are simply to help us to plan accordingly. So therefore, I would want you to help me with an electronic reaction. Could it be a clap? Could it be some love? Could it be, some acknowledgement, so that we welcome our speaker tonight to take us through this very interesting conversation. Kindly let me see you showing some love, some reactions, some welcome, some claps, and welcome so much. Esther, take your time. And to the audience as well, thank you for those reactions. And also to the audience, have your questions with you. Be set. Let's ask as much as we can, so that we can be able to learn tonight. Over to you, Esther. The rest will keep joining and finding us. Let's begin. Welcome.
Thank you so much, Doreen. Thank you so much for the warm welcome and even for having me in your platform, even to share on these very important key topics. I'm glad to see all of us. We say that wisdom, we never stop learning. Every day is a day to learn. And even as we speak on how to plan ourselves, how to do a will, what are trusts, and how to go about it, it's important to note that we, just like Dorina said, we work so hard, and it is important that we take care of our resources and we take care of our wealth while we are on this side of the sun, and even when we go. The matter is not about if, the matter is about when. Yeah, but we need to be prepared. Even Psalms 90:12 says that teach us to number our days that we may gain a heart of wisdom. So let's delve into the slides. So we are talking about power of attorney. We will talk about wills, and we will talk about trusts. And I'm sure we are all ready to hear what all these things are. I'm sure we will learn much and we will help one another to just understand the concept. So let's start with one that is a bit less complex. What is the power of attorney? When we talk about powers of attorney, we are talking about a legal instrument where a person gives another person authority to act on their behalf. For powers of attorney is not necessarily when you're dead. You can't give a power of attorney when you're not alive. You give it when you are probably not in a position to act for yourself. So that is, for example, when you are out of the country for a long time and maybe you need to do a transaction that requires your presence, or maybe in a hospital for a long time, or something that makes you absent or incapacitated to do that particular thing that you desire to do by yourself. So the Kenyan legal framework for this particular document is the Land Registration Act and the Registration of Documents Act. That one should not worry you so much, but that is where a person making a power of attorney should check to see whether theirs is in accordance to the law as it is set out. So when you want to create a power of attorney, there are major parties. The first person is the donor or the principal, and then the second person is the dani, who is the attorney. We should not confuse this to mean attorney meaning an advocate. No, no, no. This is the person that is receiving the power to act on behalf of the donor. It can be anybody. So the donor is the person granting the power of attorney to this other person. And for you to draft or to create a power of attorney, you need to have legal capacity for a country that is 18 years and above. And also, you have to be of sound mind to be able to donate that power to another person. And then there must be a witness, that is the commissioner of all, that, or a notary public. That means a lawyer. You need to engage an advocate to be able to witness that particular power of attorney. And that is very necessary, if I may insist, because the advocate will be able to let you know whether whatever you've written there is legally sound, or whether that power of attorney can be able to be enforced. So there are types of powers of attorney, and the first one is the general power of attorney. This one, it's a broad kind of power of attorney where you write, I, maybe Esther, grant so and so powers to do everything and anything that concerns my properties for as long as I am probably incapacitated or I am out of the country, or whatever the case it is with the donor. So it's a general one. It gives the attorney a lot of power. It is not specific per se. And then we have the other one that is special or limited power of attorney. This one grants the power to act on behalf of the donor for specific purposes. For example, you just want that person to act for you to sell one particular property for you. So you say, I grant so and so powers to sell land LR number this and this and this, which is located in Kiambu at this and this and this place, which means the power of attorney ends once that transaction is over. So it's a specific, very specific, and it is limited. It doesn't give the attorney a lot of power. And then we have the irrevocable power of attorney. This one, it can either show, but it cannot be terminated or revoked unless both parties agree. These others, you can design to revoke by just writing a revocation. But when you create an irrevocable power of attorney, you cannot revoke it unless the two parties have agreed. Okay, so let's get to look at the validity of a power of attorney. For it to be valid, the person must be 18 years, the donor. And then you have to reduce the power of attorney in writing. There is a specific way it looks. That is why I said it's very important to get a lawyer to look at it and see whether you've placed it in the way it should be written, or have them draft it for you. And then it must be executed. The donor must sign. Sometimes it's very, some people can be mischievous. They can say they have power of attorney and they don't have. And one of the ways to check is to see whether the signature of the donor is the same signature that they use. So it must be signed by the donor and witnessed. And this witnessed is not witnessed by a person. It must be witnessed by a commissioner of oaths or an advocate. And then the power of attorney is stamped under the Stamp Duty Act and registered under the Registration of Documents Act for it to be effective. So if you want somebody to do a transaction for you, unless you have registered, you've stamped your power of attorney, you have registered it under the Registration of Documents Act, then they cannot be able to do that act on your. So you get in touch with a qualified advocate to draft the document for you based on the required type. That is whether it is general or whether it is special. And for safety's sake, it is advisable you use a special kind of power of attorney, because special is able to limit the powers to whatever it is that you want that particular person to do for you. And then execution, of course, the parties sign the document, and then it is witnessed by the commissioner for oath. And then you take it for stamp duty, it is stamped, and then it is registered at the land registry or the registry of documents. So in case that you want to revoke it, it is possible to revoke. The power of attorney can specify the timeline. For example, I am giving powers to this particular person to act for me for the next probably 2 years. So after the lapse, it can expire. Or when the specific task, especially when it's special in nature, is completed, then that power of attorney is revoked. And then also the donor can revoke it formally. Yeah, give a notice, write a notice and register it under the registration of documents, and then that one is revoked. So, and also the power of attorney, it lapses when the donor passes away, unless it is irrevocable. Unless you've stated that it is irrevocable, then once a person passes away, every power of attorney they had is null and void. It expires unless there was a specific clause stating that the power of attorney continues to exist even if the person is not alive. So for this power of attorney, it does not last after the person per se. Usually, on most occasions, it doesn't, because it is a document that is supposed to, somebody is acting on behalf of another who is supposed to be actually alive. Okay, so a few things to note about powers of attorney. Actions done by the person you have granted power of attorney are binding. It is like vicarious liability of an employer and employee or an agent. Whatever it is the person that you have granted your power of attorney does, whatever they do, those actions are binding to the donor. So you must really trust this person for you to grant them the power of attorney. And then companies can use powers of attorney for projects, but this requires a board resolution, so that if you're sending one person to act on behalf, for example, maybe one of the directors or an employee, and you want them to act on behalf of the company, companies can use a power of attorney, and especially for negotiations and such things. And then every foreign power of attorney must actually be registered in Kenya for it to be valid for any local transactions. Let's say maybe somebody owns property in this country, and then you come with a power of attorney that is executed in US, and you want to handle local transactions, you must re-register that power of attorney in the country. So I think for powers of attorney, that is all there is. It's not a complicated document. It just looks very easy. It's especially the specific one. You just be specific about what exactly you want that person to do for you, and for what time, and when the power of attorney is going to lapse. So I hope you have questions, but let us go on, then we can ask the questions at the end. So that is all really about powers of attorney. Let's get to the place where people do not like to hear. Let's talk about wills, last wills, and testaments. What is a will? A will is a document which declares the intentions of a person regarding the disposal of their property after they die. So, and why is this important? Because on most occasions, as Africans, we don't like doing wills. We like living like that until we die, and then our relatives or the people, beneficiaries who are they're dependent on us, they start fighting in court and all that. So it is a legal document. It declares a person's wishes or intentions regarding the disposal of their property after death. And the legal framework that governs wills is the Law of Succession Act. So why write a will? Why don't we just live the way we want to live, and then we leave the properties? And there are key reasons why each of us, no matter how young or old, provided you have some property, why should you write a will? The first reason is you can control your assets after you die. You are able to say what you want to be done about your properties, about what you have, what you have worked so hard for in a will. And then the second reason is guardianship for minors. You can set out, for example, if you have children and they are minors, and you die when they are minors, you can write it in a will that this person is going to be guardian over my children and such things. And then writing a will prevents a lot of disputes, because the reason why people fight over things, although even if when you have a will, people still fight sometimes. When there is a will, there is an inclination by the people that are left behind to respect the wishes of the person who has gone. So it reduces the disputes that may arise, especially if you are able to distribute your wealth well among your beneficiaries. And then the other importance of writing a will is to avoid intestacy rules. Now, if you die without a will, there's something that happens. We say in law that you die intestate. That means you have no wishes over how your property should be distributed or how it should be used. So that means the Law of Succession Act kicks in, and it tries to say how this property shall be done if you die like that. And some of those provisions may not align with what probably you wanted as a person. So if you want to avoid those intestacy rules, you should write a will. And then the other reason for writing a will is providing for unmarried partners. Maybe you have a girlfriend and you're not married, but you want, in the event of your death, that they inherit. If you die without a will, they cannot inherit. Or other people you would, really want to leave property for, and they are not directly related to you. Without a will, it is impossible to do that, because the Law of Succession Act considers priority is the spouse, then the children, then people that are related to you, starting with maybe the father. In the event that you have no spouse and you have no children, then it is your father, then your mother, then if the two are not there, then maybe your uncles, cousins, and it goes on and on and on. The Law of Succession Act gives wide scenarios of what can happen. And if indeed you do not have any relative at all, the property is taken back to the government. Yes, Kenya will take your hard-earned money if it is found that you do not have a close relative to inherit your property. And then also, writing a will simplifies succession. When there is a will, it is a bit faster, because already the wishes of the person that has left are already stipulated in a document. And while it may be challenged sometimes, on most occasions where the beneficiaries are okay, then the distribution happens so fast. That is after the probate particular process. Yeah, the probate process. So there are two types of wills, or three. There's an oral will. You can say what you want, but now that will is only valid for 3 months. You must die within 3 months of making that will orally. And when you do the will orally, there must be two witnesses also, but that the validity of that must be you must die within 3 months. So that is not the recommended version of a will. It is important to reduce your wishes into writing. So that takes us back to the second category, which is the written will. And that one, of course, is written and then witnessed, and then it has everything that the person desires to stipulate. Then we have privileged wills. These are wills that are made by members of the armed forces. Probably watu wakifight huko Iran, and maybe they know that there is a particular possibility of getting to die, they may make wills. On many occasions, these wills may not follow the strict sense of wills, of a written will. So those ones, we categorize them differently so that they do not have to follow the key characteristics of a written will. Yeah, so they are called privileged because they do not have, they have a bit of a relaxed form of requirements. So, what is a valid will? These are very important things to consider when you're writing a will. First of all, you must be 18 years old and above. You must be of sound mind. You can write it or you can type it. So that is the written part. Then it must be signed. The testator must sign the will. And when you're signing, the witnesses must see you append the signature on the will after reading it out. The witnesses must be at least 2 of them. But these people, they cannot be beneficiaries of the will. So don't write a will and then have your wife witness it, or wife and children witness it, and then you leave properties for them. That is not a valid will. You must take 2 people who you have not given anything under the will to witness the will as you sign, as you append your signature on the will. So that is a very important point. And that is where many people actually make mistakes. And then for a will to be valid, there must be no duress. You must not be acting under pressure. You are being pressured by your wife to write in a particular way, or you're being pressured by your husband, or whichever family member, or undue influence or fraud. There are people who fraudulently, make their relatives write a will in their favor and force them to sign. If it is proved that this is what happened, that will is not valid. Okay, so this is what you must put in a will when you're writing your will. This is the first declaration. It says that this is the last will and testament of so and so and so. And it revokes all previous will that may have been made by myself previously. So it's a declaration of just saying this is the last will. Then another key component is appointing an executor of the will. The will must name a person who is supposed to manage the estate. That person is called the executor. And then there must be beneficiaries. You must clearly name who is receiving what. So, for example, I say, Ben Zion shall receive my plot number this and this and this located in this and this and this. Okay, my shares at Safaricom shall go to so and so and so and so. So the beneficiaries must be clearly stated and what they are getting. Then we have the asset listing. You must detail the inventory of your properties. That is the land, the bank accounts, the shares, the what. And one of the problems with this country is that we do things We like doing things chini ya maji sana, so that when people die, they have bank accounts that no family member knows about. And so when they die, they end up that money is not claimed because it's not known. And after some time, or after some period of time, these banks or whatever company you may have invested in are required to surrender that money to the unclaimed financial assets. So a will helps you to at least detail the inventory of your property, be it shares, be it land, be it, you list all of them, so that the person who will be executing will know you have shares at this, of Safaricom, you have shares with KCB, you have, some land in Kamulu, and all that, and so forth. Then you can have a guardian clause. This one is not compulsory. In case you have minor children, you can name guardian, who on most occasions will be taken care of by the person you have named as a guardian, and what they're supposed to receive will be under trust, in a way that those guardians are to use those properties for the benefit of the children. So it creates a somewhat of a testamentary trust. So in a will, you can do that. You can name. So it becomes a resulting kind of trust. Okay, so what happens when somebody dies and they have a will? The first thing, the executor has to obtain the death certificate. That is why it is usually very important when a loved one dies, ensure that you get the official death documentation, the death certificate. So that death certificate is very important because it will be used to do the petition for probate. People ask, why do you have to go to court if somebody has died? You must inform the state that somebody has died and they had properties for you to be granted the right to deal with their property. That is the petition for probate, and it is filed in the High Court. So you file the will with it, and then there's a petition, and there's an affidavit, and those documents, please get a lawyer to draft them for you so that they can be proper. So you file the case in court, and then the court gives you the go-ahead of there's a publication. Actually, it is done by the court itself in the Kenya Gazette to say that so and so, acting as an executor of the will of so and so, has filed a petition for grant of probate. Anybody who has objections, they can come forward to claim anything they may want to claim. So when it is published in the Kenya Gazette, it is given a waiting period of 30 days, just in case they are members of the family or people who have been left out in the will and they have objections. So after the 30 days, if there is no objection raised, then the court issues the grant of probate. Yeah. So after that grant of probate, there's another waiting period of 6 months for the executor to now go and gather all those properties. Usually they are all over the place. For example, maybe you had land in where the executor has to go and confirm that it is there. You had shares, you had monies, you had what? So they use the first grant, probate, the one that is granted after 30 days to just confirm everything is in order, and then after the 6 months they apply for confirmation of grant, and that is usually the final part. After that, they can go ahead now and distribute the property to the beneficiaries as per the wishes of the person who was making the will. So it's a process. It doesn't happen in one day. It happens, you can say, almost around a year before the properties of a deceased person can be able to be distributed. Just something to note, anybody who goes ahead to distribute or to use the properties of a person who is deceased without this process is actually committing a crime. It's called intermeddling. Intermeddling. You are a criminal for using the property of a dead person without the proper process and being given the permission by the court to do so. Although it happens a lot. Yeah, people even sell without those letters, the grant of profit. So there are some common mistakes to avoid. And the most common ones that we have seen is failing to have the will witnessed correctly. Sometimes you can have people there, but then they are your beneficiaries, they are your children. That will not be a valid will. Or you forget to update the will after major life changes. For example, you are married, now you are divorced, but then maybe the sole heir of your property is your ex-husband. Now it doesn't make a lot of sense. Or you had children and you did not update. You said that the beneficiaries are your parents. Now you have 5 children, so you have left out your children out of the will. And as far as it can be shown that that was the last will you signed, that is what will take part. Of course, the children have the authority, or they have the right to challenge that in court and have the court make a provision for them. So it means when you write a will, just write it, put it somewhere, but every time there's a major life change, just update it. Keep updating it. There's no harm. And every time you update it, go and take it to an advocate. Have it stored every time you update, so that it's updated with your life changes. So another mistake is appointing a beneficiary as a witness, as a no, I think this one I meant as yes, as a witness, and then not storing the will in a secure, known location. Sometimes people die with wills, but it's not known where that will is. It is very important to secure the will. You can store your will in a bank, or you can store it with an advocate that you trust, or with a family friend who is trustworthy, so that in the event of your death, they can be able to come out and say, this is the will that your person left. So don't store a will in a place that cannot be traced, because that will mean you just died intestate, because nobody can be able to track your will. Okay, so my conclusion on this will be that writing a will is not inviting death. It is responsible estate planning. It is important, because when you write a will, it helps you to plan. It helps you to plan where these properties will go. Even it helps you even to give to charity sometimes. When you write a will, you can say a particular amount of my money I want it to be used for education of so and so, you know. So otherwise, it would not be possible if you die without a will. Then a will protects your loved ones and ensures your assets go to your chosen beneficiaries. It is very important to do this, because we know, we have seen all the wrangles that happen when somebody dies, because it's everybody is fighting to see that they get something. But if you've said something, if you've set your intentions clear, then it is going to be easier. The court can make a proclamation on your will that it is valid, and that is how your properties are going to be subdivided. Yeah, so My recommendation at this point is to seek legal counsel during drafting and enforcement of the will, because when you do that, it helps for you to know whether what you have written makes sense legally, is enforceable legally, especially your choice of witnesses and how you have articulated your will, so that it is easier. You know, and you are sure that in the event that of your demise, you have a valid will in place. And that is all about wills. But before I conclude on wills, if you don't write a will, what happens? When you die, it is said you die intestate. And when you do that, still somebody who is your personal representative must go to court and say, our father or our mother or our brother died without a will. We are asking the court to give us letters of administration to be able to administer their estate. So when a person does that, they have to come with a list of all the beneficiaries. The challenge of this is that the person who goes to court may leave out some people you wanted to include in your will. Or in the event of polygamy, which is common, if the first family or the second family go first, they can leave out some of the beneficiaries. And if by the time the people that the other family realizes, and the court has already made a confirmation of grants, they may meet that the property is already subdivided, and there may be no recourse because it may be too late. So for you to be safe, it's better for you to write a will to ensure that everyone you would like to cater for is catered for in that particular document. Yes. So, and as I said, the Laws of Succession Act, the Law of Succession Act takes control now. Once they just set out the people that were left as beneficiaries, they will be divided as per the Law of Succession Act, what it provides. And it provides several things. For example, if it's a man who has died and they had a wife, the wife gets life interest of all his property to hold for her lifetime until her death. If she remarries, that interest goes, and the properties go to the children. So there's a life interest for the spouse, and of course the law is a bit discriminative. If the man remarries, that does not apply, but if the woman remarries, that life interest of her husband's property goes to the lapses and goes to the children. Okay, so that's all about wills. I'm sure we'll ask questions and we'll be able to explain more and be able to get into it and to understand the concept a bit more. So let's look at trusts. What are trusts? Having looked at wills, today there's a run into trust because people don't trust wills. But it's actually a good way of estate planning, because you can do it. It doesn't take effect when you die. It can take effect even when you are alive, and you can be able to manage your property even as you are alive, as you still pass it to your beneficiaries. So what is a trust? A trust is a legal arrangement where asset law transfers assets to trustees to manage for the benefit of beneficiaries. This is how it works. I have a plot of land. On it, I have built some rentals, probably. And I want that property to be in trust. For them to be in that trust, I must transfer my title to that property, to the trust, if incorporated, into the name of the trust, if not incorporated, to a trustee to hold and manage for the benefit of my beneficiaries. So I no longer have title over that property, but the trust has title over the property. And I can make myself one of the trustees, but when I die, the trustees continue to manage that property for the benefit of my beneficiary. So that is how it works. So there must be property, there must be cash, there must be whatever assets you're placing in the trust, and then there is a formal transfer of all those assets to the trustees. You can have one or you can have a number to manage. They will manage during your lifetime and they will manage even after your demise. Okay, so what are the types of trusts that we have? We have the family trust. This one is designed for family wealth, succession planning, like I've just said right now, and protecting assets from creditors. So if I owe somebody money and I have already transferred that property into a trust, they cannot go after the trust because that is no longer me. It's no longer mine. They have already passed the title. So it can protect those assets from the creditors. And that is why many people are forming trusts. Then we have the charitable purpose trust. These ones, you can establish a trust for public benefit. For example, these foundations that are being formed here, you can have a trust maybe to support education or people living with disabilities. You can have a trust to support health of people. You can have a trust to support the spread of Christianity. You can have a trust for very many things. So that is charitable in nature because it is established for public benefit. It has to be some public benefit purpose. And then we have others that are called non-charitable purpose trusts. These ones are trusts formed for any other purpose other than charitable. So probably it's not going to be something that benefits the society per se. I can create a trust. Okay, this we see in the Western world so much. I can create a trust for people to take care of my dog or something. Because dog does not fit in the family trust or something. But a trust that is not for any charitable purpose. And that depends on now when you're registering whatever it is that you put there. Okay, so what are the advantages of trusts? Now, as we have said before, the wills take almost a year or something in the courts before there is transfer of wealth. But for trust, your property can even pass as you still continue to live. So it avoids delays of profit and ensures just seamless wealth transfer. I've already stated that if probably my son hits 16 years, he is entitled to around 2 million. So by the time he hits 16 years, whether I am alive or not, the 2 million already is transferred to his account or whichever way. So it avoids that delay of profit. And then there is asset protection. Assets in an irrevocable trust are generally protected from personal creditors and lawsuits. So sometimes it's very hard to sue. It's not even, you can't sue a trust because the settlor has your money. You cannot do that because those are different entities. Then there's privacy. The structures are private and not public record, so you can be able to just probably just ensure that your property is well organized and it is a private structure, so you do not have to worry about people getting to see who you are, provided of course your trustees are trustworthy people. Then it enables professional management of assets for beneficiaries, that is especially minors. Okay, so what is the process of setting up a trust? The first thing you need to do is to draft a trust deed. That one you actually need to do a very good job because you need to state the purpose, you need to put the trustees, you need to put the beneficiaries, and you need to state how the trust is to be ran. How are the properties going to be managed? So it is like the constitution of the trust. So you need to have a competent professional do that for you. And then there is the stamp duty. The deed must be stamped at the lands office and then registered there under the Registration of Documents Act. Then incorporation is registered at the trustees. Oh, it is registered under the BRS. That is under the Trustees Perpetual Succession Act. This process is in transition. As you can see, there is the land side, and then if you want to incorporate, you come to the BRS side. BRS is Business Registration Service. But this process, we are working towards having trustees fall under one umbrella so that it can make it faster to register. So BRS should be the one running from one to the end of the process so that it is a bit automated. So there is transfer of assets. The legal title now as of assets moves to the trust or the trustees. When it is incorporated, it goes into the name of the trust. When it is not incorporated, when it is only registered, those assets are held by the names of the trustees you have chosen. And that's why there was a lot of mismanagement in the past. So it's better to actually incorporate one. So requirements for incorporation, you need a proposed name, you need the purpose of the trust, you complete a form called Tier 1, and then you have a petition, which must be commissioned, and then the registered trust deed. When you create the trust deed, you register it at lands. And then minutes appointing trustees, CVs of trustees, title deeds or asset documents, and the incorporation fee. Then you need, of course, the title deeds that belong to the trust that you have transferred to, you're transferring to that trust or the trustee. And then current search indicating the ownership has moved from yourself to the trust. And then financial statement of the organization or of one trustee, such as current bank statement. If you're transferring to the trustee have to give us their bank account so that it is clear that the money has been deposited there. Or if you're working with a corporate trustee, there are those that are called corporate trustees. They are corporate agencies that act as trustees. Yeah, we need their financial statements. And then, of course, the certified copies of ID, KRA PIN, and passport photo of the settler, trustees, beneficiaries, and enforcers, if any. Enforcer, I did not say about enforcer. Enforcer is, when you put trustees, of course, there are people you trust, and maybe there will be others that are professionals that you put there as trustees for your trust. You can even put yourself as one of the trustees. in the existence of as you continue to live. But in the event of your death, you can put in the trust deed, you can put an enforcer. Enforcer means a person who will be looking at whether the trustees are doing the right thing according to the stipulation of your trust deed. And if they are not doing whatever they're supposed to do, then that enforcer person can go to court and challenge for the benefit of the beneficiaries, because trustees have a fiduciary duty to act in good faith. So an enforcer is also a very important person that you should have, but they do not have power to manage the properties themselves, the enforcer. They can only go to court, maybe challenging the actions because they are not probably in the what you put in the trust deed, or maybe some they are mismanaging the assets of the settler once they have died. Okay, so challenges of trustees. Sometimes there's governance gaps because you can put trustees who are family members without any professional knowledge to be able to run this trust. So usually it doesn't always go very well. Then conflict. Sometimes conflicts may come up, especially when you have one or more trustees and they can't agree on what decision to make, especially when you've given them this. Of course, it's not possible to put all circumstances in the trust deed. So there are usually maybe clauses like where scenarios are not stated in this trust deed, the trustee shall agree. And then the trustees don't agree. Now it becomes a problem, becomes a conflict. Tax compliance, KRA started looking into trust a lot because it's one of the ways to evade tax with properties. Then trusts usually are presumed to be irrevocable unless you have stated it in the trust that you can terminate. They're supposed to be irrevocable. Once you pass your properties to the trust, you cannot take it back. You cannot say, I want that high-rise building. I put it in the trust, I need it back. No, it is not possible unless you state in the trust deed expressly that you can terminate. But then that would give a very difficult situation, especially because the trust may have debts and other things. Because it can be able to, the trust, when the trust is running, it can, especially for charitable cases, charitable trusts, they actually carry out some investments and such. So they can get into debt, just like companies and all that. So when you say you are revoking it, it will not make sense legally. And then, of course, the registration takes significant time, at least 6 months. As you move from lands back to BRS, 1 year. In some cases, it can actually take a bit more time, but there are efforts to actually make this a bit more seamless. Hopefully, what we are working on is going to help the process to be easier and faster. Yes, and that marks the end of my presentation. I am sure we have many questions, and thank you very much for listening to me. Back to you, Doreen.
Wow, thank you so much, Advocate. And why can't we just go to the reactions and celebrate our senior advocate of the High Court of Kenya? Wow, this is beautiful. Thank you. Thank you so much, Esther, for taking your time to take us through this. We started with the poor, we got to the will, and now trust. Wow, wow, wow. For me, writing a will is not inviting death, and it's responsible estate planning. That is something that we shouldn't leave out. As we started by saying, we make all efforts to ensure that we gather all these things. And it's also good for us to plan well, to exist and exit well. Wonderful, wonderful, wonderful. I know there are many, many questions that we are to have our advocate respond to for this remaining 30 minutes. That was awesome. Thank you so much, Esther, for taking your time. And I'm sure you'll give more clarity maybe by the questions that we are going to ask tonight. And to start us with, I would encourage us to put our questions on the chat, and I'll be able to look at them and read out. And there are some questions that came in when we were for the people who did their registration. And I'll start with this one. Esther, allow me to read out this, and the rest of us, feel free to put your questions, your concerns on the chat, and they will be responded to. And the first thing is this: if an elderly individual has long-standing signs of mental instability or paranoid beliefs, how is testamentary capacity evaluated, and can concerns be raised before death to prevent future disputes? Maybe I repeat again. If an elderly individual has long-standing signs of mental instability or paranoid beliefs, how is testamentary? Wow, okay. Capacity evaluated, and can concerns be raised before death to prevent future disputes? That's the first question. Maybe let me read these three, Esther, and then maybe you can respond to them. How is the nomination of beneficiaries? How is the nomination of beneficiaries? And when a will can be challenged? I'm sure this one you've been able to mention in your talk, but for those who've come later, maybe it is good for you to highlight that when a will can be challenged. And then I'm going to read some few more. And please keep putting your questions on the chat as Esther responds. So over to you, Esther.
Okay, so let me start with the first question. A person has been having maybe mental instability, or they believe, weird paranoid beliefs. How can you test this testamentary capacity? Now, the test is usually, does this person understand what they are doing when they are making the will? And do they understand their property? And do they understand who are their beneficiaries? If that can be proved to be an answer in the positive, then it will not affect the validity of that will, because it can be shown that they can understand that they are making a will, and they can understand what are their properties currently, and they know who are their beneficiaries, all of them. So always ensure there's something called fluid season, fluid time. Even when somebody has mental incapacity, sometimes they have that period of sanity. If it is proved that they created that will in that time of fluidity, then it is still valid. If it can be shown that they understood what they were doing, what was their property, what were their beneficiaries, it is a valid will. Then it is important to note that the court presumes that the testator has sound mind all the time, unless it is proved otherwise by the person challenging the will. But there must be evidence that actually they were not okay, especially if the insane delusions affected the property distribution. If you can show that, for example, maybe an old person thinks maybe their second born wants to kill them, okay, in an insane way, not that they actually want to kill them, and then maybe disinherit them in the will. If you can prove that, then these insane delusions caused and affected the property distribution, then that one will be declared an invalid will. Yeah, so it is a test on a case-to-case basis. Can the concern be raised before death? Not much can be done because you can't. A will is discretionary. It must come from the testator. So you just have to wait for them until they can be able to. If they understand what they are doing, then the will can be said to be valid. Okay. The second question was, how do you nominate beneficiaries? In a will, you can nominate anyone to be a beneficiary, but first you need to consider that you must take care of all the people that are your first biological children. If you disinherit one, that one can go to court and ask for a provision because you are supposed to provide for your children. So you can nominate anyone that you want, but don't leave out that the ones that are supposed to actually inherit your property. That is the children. There's no need for spouse anyway, but please also put your spouse. um, and your close relatives, those that you actually want them to, to inherit your property. So you just nominate. You state this person, they are my child, they will get this. This person, they are my spouse, they get this. This one is my mother, they get this. Yeah. Okay. And then the third question is, when can a will be challenged? The first reason is that will can be challenged is when it is not properly witnessed. Like we said, most people make the mistake of maybe having their relatives or people who are actually beneficiaries under the will witness the will. That is not correct. So it can be challenged because it will be shown that they witness like that because they have beneficiaries in the will. And then when the testator had no capacity, maybe if he was not okay mentally, it can be challenged. And then also if it was done under duress or undue influence, sometimes people force people to write wills. If it can be proved that actually you wrote the will under duress, then it can be challenged. And then also, when the will disinherits a legitimate beneficiary, a child can go to court to challenge a father's or a mother's will when they are left out. Unless unless that child had something to do with the death of the parent. That if it can be proved that way, the court will disinherit the child also. Yeah, so those are the different scenarios that can happen and the will can be challenged. Yeah, and there are many other scenarios that it can be challenged, especially maybe if you feel it was unfair, especially the beneficiaries. Yeah, thank you.
Wow, thank you so much, Esther. I can see questions are coming in. They are streaming in. And please handle these. How does a woman handle joint investing on a property under the husband's name? How does a woman handle joint investing on a property under the husband's name? Yes, maybe you can take that up. And also, is there a difference between an executor and administrator in a will? Is there a difference? And then what happens if an advocate who is the custodian of the will dies? I think I heard also that question. Yes.